Welcome back to Good Law, Bad Law. My guest on this episode is Jennifer Pizer. She's the Law and Policy Director for Lambda Legal, the largest LGBT civil rights organization in the country. Now, you've all probably heard this week that the U.S. Supreme Court decided the important case of Masterpiece Cake versus Colorado, the case of the baker who refused to make a custom wedding cake for a same-sex couple. But you haven't heard all that there is to know about the whys and what's going on in this case, and what does this say about what's going on in our country at this time, the tension between an individual's right to religious liberty, to personal freedom on the one hand, and the right of all citizens to be treated equally in business, in the marketplace, in our society. That's what this case is really about, and that's what the conversation you're going to hear today is all about. I know you're going to enjoy it. Fascinating conversation with Jenny Pizer. Stay tuned. My guest today on Good Law, Bad Law is Jennifer Pizer. She's the Law and Policy Director for Lambda Legal, which is the oldest and largest national legal organization devoted to civil rights for lesbian, gay, bisexual, and transgender people. So first of all, Jenny, thank you so much for being on the program.
It's my pleasure. Delighted to be with you.
And it's very fitting and proper this week, especially because this is the week that the U.S. Supreme Court handed down an opinion in a much anticipated case, the Masterpiece Cakeshop case involving the baker in Colorado who refused to participate in a same-sex marriage, refused to provide a wedding cake to a same-sex couple, claiming that it was a violation of his deeply held religious beliefs. And the Supreme Court, in a 7-2 decision this week, sided with the Colorado baker and against the same-sex couple. So it's a really important decision, perhaps a narrow decision, but still one, I think, with really significant implications. And we're going to pick it apart today, Jenny, and I really appreciate you helping us do that. First of all, though, I want to try to get some background on you and tell us about yourself and Lambda Legal and the type of work that you've been doing in this area for the last bunch of years.
Sure. Well, so I am a senior lawyer at Lambda Legal. We're a national organization that does LGBT civil rights work. I've been with the organization for more than 20 years, and of course the legal landscape has transformed enormously over those years, I think in some important ways, some exciting ways for same-sex couples, their families, and LGBT individuals. Lambda Legal works out of 6 offices nationally. Our newest office has opened following the 2016 election in Washington, D.C., and I'm based in our western office in Los Angeles. I personally have worked for many years dealing with these questions of the relationship, some say the intersection, between everyone's equality rights under the Constitution, state constitutions, and laws. So everyone's right to be equal and everyone's right to have important personal freedoms, including the freedom of religion and free speech. Sometimes those rights come into conflict, and those conflicts are as old as our country. The courts and our Supreme Court has been grappling with these questions as long as we have been a nation. So the Masterpiece Cakeshop case is one more example in a long line of cases. Personally, I've litigated cases that, for example, on behalf of a lesbian patient denied medical care because her doctors had religious objections to providing that care to a woman in a same-sex relationship. We've had cases about equal access to employment benefits, and of course, cases about whether states must recognize equally same-sex couples in marriage and with respect to parental rights. Frequently, we have faced objections in court and in legislatures that same-sex couples and their families should not be recognized in the same way as different-sex couples because of religious objections to those relationships. And we always then come back to these core principles about how our government should protect everybody's religious liberty, but also protect everybody from other people's religious liberty so that we can all be equal and have the same basic rights and the same rights in the marketplace. Want to sort of focus on the fact that the Masterpiece Cakeshop case, which came out of Colorado, is like a couple of dozen cases that are arising in places where there are laws in place requiring equal treatment in the marketplace from businesses. Those who are offering goods or services to the general public being required under state law or under a local ordinance to not discriminate based on sexual orientation. Only when those laws are in place would you see a case like Masterpiece where somebody is objecting to following that law, that non-discrimination law, because they have a religious objection and want to engage in discriminatory conduct. This, of course, is our view, that it's discriminatory conduct to refuse goods or services to some people, to gay people, or to a same-sex couple for religious reasons. You don't have that kind of a disagreement if there's no law in place requiring equal treatment of gay people.
As there is in Colorado.
As there is in Colorado, exactly right.
And we're going to really need to, I think, set the table, so to speak, and lay out the key facts in this Colorado case, because the way the Supreme Court tackles this and tries, as you say, to grapple with the intersection between the right to personal freedom on the one hand and the right to equal treatment on the other, is so very fact dependent in this case. And so I want to do that. But before that we do that, you brought this up, and I was going to ask you about this in terms of your own background. The case that you mentioned where you won, and I'm getting this from your bio, but I'm going to ask you to tell us a little bit more about it. It was in 2008, I believe, that you won a unanimous victory before the California Supreme Court in a case involving a lesbian who was denied infertility care. And the claim there was by her physician that he had a religious objection to providing that care to her. That I wanted you to just say a few words about that case, because I think that, first of all, it shows that these conflicts have been around, as you say, for a long time. And I'm interested in how that case resolved and how the California Supreme Court resolved that conflict as we lead into a discussion about this most current case that the U.S. Supreme Court decided.
Sure. Well, so this was a case where the refusal of medical treatment happened back in 1999. My client was part of a health plan. She was a healthcare worker and received healthcare benefits as part of her compensation for her work as a healthcare worker. And she had one in-network provider of infertility care, this particular for-profit medical clinic not too far from her house that had 4 doctors on staff. And the one to whom she was assigned, the woman physician, they were all infertility specialists, and the doctor is an infertility specialist. It turns out that the care that was needed was an insemination by the physician, not something an individual can do for herself. Many other things had been tried, and the patient had tried lots of things, and this was the next appropriate medical step. It's a procedure that's done day in and day out by doctors who work in this field, who specialize in infertility care. And the doctor, in this instance, said that she would not perform this procedure for this patient because she had a religious objection to doing so for a woman in a same-sex relationship, for, as she said, for a homosexual person. And this then created a tension between the patient's right under California law to be treated equally with respect to medical services, and the doctor saying, well, but I have religious rights, and I don't want to provide this service for this person. So we were litigating that question. There were some arguments about facts, but they really were to the side. The legal question was pretty squarely presented, and it went.
What was the religious objection in that case? Was it that she was in a same-sex relationship, or was it to providing any medical care to a lesbian or to a gay person? What was the religious argument?
The doctor said that self-identified, these are her words, that she sees herself as a Christian fundamentalist, and she believes that she should only do that insemination procedure for a woman patient who's married to a man. It wasn't, as we got into the case, her explanation was, well, it wasn't just about being married, because during the course of the litigation, California's marriage law changed, something I personally take pride in. I was part of the legal team that won marriage for same-sex couples in California, and during that period before the passage of Proposition 8, my client did get married, and the doctor explained, well, that really doesn't change her position, her religious objection, because in her view, marriage should only be between a man and a woman, and the patient being married didn't matter as long as she was married to a woman who was her partner of many, many years. So that was the religious objection. It was not that she would provide no medical care at all. So there are some important parallels to the issues in the Cake case. She was willing to prescribe infertility medication. She was willing to do a range of tests. She was willing to do various things, but she wasn't willing to do the one thing that the patient needed. The key issue on the table, if you will, was about doing an insemination. And so thereby lies the dispute. And the physician said, again, much like the situation in the Cake case, well, I don't hate gay people. I don't see myself as discriminating. I'm willing to do various things, but I won't do this thing that you need. And this thing that the doctor provided, as I said, pretty much day in and day out for other patients. So it wasn't an objection to that medical procedure. It was an objection to that person, and that's why it was a discrimination case. The Supreme Court said, did a quite detailed explanation that under the federal constitutional case law that we've had for quite a few years, the doctors were required to follow state law if it was neutral and applies generally to everyone. There's nothing that's picking on Christian fundamentalists there. Again, we have a parallel to the Cake case. The law applies the same way to everyone and is being applied in a neutral way, and it's not an anti-religion way. All doctors have to treat all patients equally. So the doctor's argument does not succeed under the federal constitutional analysis. Under the state constitutional analysis, the court said the doctor also does not succeed because even if we use the most rigorous constitutional test, and that's different from what we have had in federal law, but under California law, it's been unclear how rigorous the court needs to be in vindicating religious rights. We still are not clear under California law. But even if you use the most rigorous test, the doctor still has to follow the law because California has what we call a compelling interest in enforcing the non-discrimination laws to protect everyone. It's not just about protecting lesbian patients. It's about protecting everyone. And the law that prohibits discrimination is the least restrictive way. It's the most closely tailored way to achieve that compelling goal. In other words, it doesn't prohibit any conduct going beyond the conduct that is the harmful conduct. So because there's a compelling interest, because the law is the least restrictive means of pursuing it, doctors have to not discriminate against lesbian patients. That was what the California Supreme Court said unanimously. The Supreme Court might have said some other things about other related issues, but the opinion really stuck to the issue on the table, and that makes it a little bit different from the Masterpiece Cakeshop decision that we just got on Monday.
So I'm wondering when you read Justice Kennedy's opinion and the concurring opinions, uh, it's obvious that the focus is on this tension, as we've called it, between non-discrimination on the one hand and personal freedom, and specifically religious freedom, the freedom to act based on your religious beliefs, and the right not to be forced to act in violation of your deeply held religious beliefs. I mean, it seems like the U.S. Supreme Court, if it was to hear that case involving this infertility doctor, might very well reach a different conclusion.
Well, that is part of why Lambda Legal's reaction to this decision um, was to express a lot more concern than what some other people have expressed. And so let me explain a little bit. Lambda Legal submitted a friend of the court brief in the Masterpiece Cakeshop case, and I was the lead author of that brief. And what we provided the court was a compilation of examples of discrimination against LGBT people and same-sex couples in particular, much of it based on religion, but other discrimination not based on religion, where our point was to say to the court, this is about a lot more than cake. That it continues to be an enormous problem for members of our community, that discrimination way too often is an everyday occurrence. It does involve refusal of medical care. We're litigating a case that was about refusal of lodging. There's cases about refusal of access to public places, discrimination in taxi cabs and other types of transportation, even in a U.S. government post office. Unfortunately, there are way too many examples of discriminatory treatment. And it's a real problem when people of goodwill and good faith believe that their sincere religious beliefs entitle them to not follow the law. One of the things I feel I took from the healthcare case was that the doctors were sincere both in their religious beliefs, but also in their belief that religion permitted them to violate the law. They were incorrect in that, but there was a confusion there. So in the Cakeshop case, among the things that's concerning is Justice Kennedy appearing to be trying to say to all of us, can't we just resolve these things? Can't we all just get along? The religious beliefs are quite important, and of course, for LGBT people, it's very important not to be turned away from a business or from any entity, any agency that's offering goods and services to everyone, but just not for your kind of person. I mean, the problem of discrimination in public accommodations, unfortunately, it's an old one, and I often scratch my head in puzzlement and dismay to think that the lesson that we should have learned as a country through all of the work and the terrible sacrifices and the difficulties that people went through to challenge race discrimination and to have it established in law that nobody should be ostracized that way. Nobody should be turned away. If you're operating a business, your responsibility, and it should be a responsibility under law, is to treat people equally. Now, of course, people who believed, and some who still believe, as a religious matter, that the races should not mix, are absolutely 100% protected in that belief. But what we should have learned through the process of challenging racial segregation is that people who hold that belief are not entitled to act on that belief when they're doing their business. And the same has to be true when we're talking about same-sex couples. So when Justice Kennedy writes with great concern and solicitude about the baker's beliefs, without any sense that it's appropriate to critique those beliefs, that's of concern. What our medical care Yeah.
Well, that's what we have to get into, because Kennedy makes it very clear that it's not the government's role to pass judgment on beliefs, and particularly religious beliefs when we have the First Amendment. Um, and we should also remember that Kennedy is the one who wrote the opinion in the Obergefell case, recognizing a constitutional right to equality in marriage. So he's, ultimately he's coming down on the side of the religious beliefs of this individual. But well, we have to get the facts on the table. We have to get the facts clear here to really understand how this breaks down. And really starting with what you pointed out, which is that Colorado has had, like many states have, and has had for a very long time, a law on the books. I mean, it goes back almost to the time of Colorado's statehood, a law on the books that protects against discrimination in public accommodation. So that would include business, including private businesses, and not limited to businesses that are in some way funded by the government or have some direct government connection, right? That includes all businesses. A law in Colorado that protects against discrimination. We have to kind of start there.
That's right. That's right.
And then you have that. Then you have the facts. So give us a synopsis of the key facts here, because that's really essential to understanding what the tension is as it plays out here.
Right. So the facts are pretty simple and not really in dispute. So Charlie and David, a gay male couple, went to this bakery, owned and run by Jack. Jack makes a range of baked goods. He specializes in wedding cakes, and he puts lots of effort into designing cakes for weddings. Charlie and Dave explained that they wanted a cake to celebrate the wedding that they were going to be entering into in Massachusetts. They're Colorado residents. They were going to have basically a reception back home for friends and family who were not able to travel to be at the actual wedding. At the point that it was explained that the cake was for the two of them, for their wedding, Jack said, "No, I don't do wedding cakes for same-sex couples." And the record includes facts that he previously had said that to some other same-sex couples. So it was his consistent position.
And also, it also comes out, and this is in, I think, one of the concurring opinions, he was fairly consistent, to give him credit, because one of the things that's important here is, are these religious beliefs, and are they sincerely held religious beliefs? And there's other facts in the record that suggest that certainly they are. For instance, he also wouldn't do Halloween cakes because he had a feeling that Halloween is a holiday that runs counter to his Christian religious beliefs. So there's other facts in the record that attest to that.
I think there's not been any suggestion that this was just a convenient, insincere excuse on his part. That these are his beliefs. So the process under Colorado law is that if somebody feels their rights under Colorado, their civil rights under Colorado law have been violated, they can file a complaint with the state agency that then investigates and may conduct a hearing and render an administrative decision. That happened in this instance, and the agency concluded that, yes, the law had been violated, and the couple's rights had been violated, and then there was an appeal taken within the state agency process, and that decision was confirmed, and then Jack the baker took an appeal to the state court of appeal. That's the process under state law, and the state court of appeal issued a decision applying the legal analysis under both federal and state law, and concluding that a person operating a bakery like Jack's, with the beliefs that Jack has professed, nonetheless, it's a violation of state law, and the rights of religion and the rights of speech do not excuse the refusal to treat a customer differently or customers differently because of sexual orientation. That decision is consistent with now a body of state court decisions dealing with similar issues. There actually have been, I think at this point, somewhere between 1 and 2 dozen similar cases involving goods and services related to same-sex couples' weddings or relationship celebrations. And they are, the state decisions are very consistent in saying that under existing state and federal case law, the non-discrimination law should prevail. And an important part of the analysis does relate back to cases about race discrimination based on religion, which was an important part of the argument a couple generations ago, and also sex discrimination and some other kinds of discrimination. The Supreme Court, back when it was looking at questions of religion-based race discrimination, said, called that discrimination a moral evil. Did see the court's role as it being appropriate to be critical of race discrimination, whatever the motive, including if it's a religious motive. So there is a different kind of treatment happening now in this Masterpiece case. Not to jump ahead, but in terms of the facts of the Masterpiece Cakeshop case, after the Colorado Court of Appeal issued its decision saying state law needs to be followed, then there was a request to have the Colorado Supreme Court consider the case. The Colorado Supreme Court did not do so. Then there was a request to the U.S. Supreme Court to consider the case. That request, or cert petition, was there waiting, pending for about 11 months, during which we had the 2016 election, we had Merrick Garland's nomination not proceed, and we saw Justice Gorsuch confirmed, and a little bit after that, the Supreme Court agreed to take the case. Much as with the marriage cases, we saw a great raft of friend of the court participation on both sides of this case. By my count, there were about 50 friend of the court briefs supporting the baker, about 45 briefs supporting the couple, and of course, many of those briefs had many organizations on them. So it was another one of these cases representing an important moment in our national history and Supreme Court focus on what are the rights, what will the rights of same-sex couples be, and what about people who object. And what we have in this decision, which we can unpack a little bit now, is really a dodge of the main question on which we're focused. The religion and speech rights, and instead a decision that tells us some important things about how each of the justices is thinking, but it rests the decision on some things said by the agency folks in Colorado. So we could talk about that for a minute.
Yeah, I think we need to talk about both. You're right. I mean, and I read this the same way. The focus, the way Justice Kennedy reaches the decision, and this wasn't a close decision either. It was a 7-2 opinion. The court's often, thought of as being very polarized, and there's, often one justice, and often it's been Justice Kennedy in recent years deciding important cases by a 5-4 decision. But this was a 7-2 decision with only Justices Ginsburg and Sotomayor in the dissent. But the way he reaches the decision, as you point out, is really to focus on the way the administrative agency handled this dispute rather than getting at the real core issues of this tension between, as we've been saying here, personal freedom on one hand and non-discrimination on the other. So I think, and we can talk about the implications of this, I think, and we will want to as we get to the end of our discussion. But this question of whether an individual business, and this is a small business, there are, who knows how many hundreds of thousands of millions of small businesses around the country, that the idea that this business person can be told what to do or what not to do when he has religious beliefs is what I think has a lot of people wondering, what are my rights and when does the government have to come in and tell me what to do? But you're bringing in a really important historical precedent for all of this. And I think you need to say a little bit more about that, because we do have a legacy of discrimination in this case, against racial discrimination. It wasn't until I think it was 1972 or 1973 that the Supreme Court finally said that a state couldn't pass a law banning interracial marriage. So we've had a lot of a long and terrible history of discrimination, sometimes where there's been an attempt, and maybe even a very good faith or deeply held belief that there's a religious basis for that. And you're saying that the Supreme Court has not accepted that historically, has not allowed an individual to say, well, but I have a religious belief that there shouldn't be interracial marriage, or I have a religious belief that there shouldn't be, that I shouldn't have to serve blacks in my restaurant or women in this club. That the religious beliefs are not accepted.
That's right. So many folks may don't remember personally, but it's a very important part of our history that there were many and deeply held, sincerely held religious beliefs that the races should not mix. So the interracial marriage case, Loving versus Virginia, one of the best named court decisions,
Right.
addressed the fact that case, when it came up through the Virginia courts, the courts accepted, the state law in significant part. I mean, the state judges talked about that religious belief. In fact, it's in one of the opinions. If the good Lord intended the races to mix, he would not have put them on separate continents. This is, and the barbecue case, the Piggy Park case, which also has an awfully good name, was about a barbecue restaurant that had service in the restaurant and takeout service or drive-through service, and the owners professed sincere religious belief. It was, somewhat common at the time that the races should not mix, and that they said, look, we're not discriminating. We will provide the barbecue, but only for takeout service, and the in-restaurant service is just for the white patrons, but we're not discriminating because everybody gets barbecue. That is similar to the argument that Jack the Baker is making, that he will make cakes, he will make brownies and pies and cookies for same-sex couples, but he won't make a wedding cake. And the distinction, of course, is it just about a sandwich or a barbecue or the cake, or a baked good of some kind, or is it the same treatment that you're offering anybody else? Now, the California Supreme Court gave an analysis to this kind of question in 1996 in a case that was about housing and a religious objection that a religious landlord had to renting to an unmarried heterosexual couple who she feared would have sex in the apartment, and that she would be complicit in their sin of sex outside of marriage. The California Supreme Court said, based on lots of prior precedent, look, if you are deciding what business to go into, and because you know your own religious beliefs best, that you're likely to come in conflict with the fair housing law, you need to not be working as a landlord, because whether it's discrimination against interracial couples or unmarried different-sex couples, same-sex couples, people of a different religion, if a landlord felt I can't rent to someone who's not kosher, because that's against my religious beliefs, the person choosing to make their living in a particular way should have a duty in the first instance to know, I can do these things in compliance with the law. My religious beliefs would require me to discriminate against some people. I hold those beliefs dear. I want to follow my religious teachings. I need to make my living a different way. That had been a clear principle in the past. Part of why we're troubled by what Justice Kennedy said here is that he seems to have a bit lost track of that. Now, I want to stress he did cite approvingly the Piggy Park case, and he cited approvingly some other important cases that confirm some of these principles about discrimination as they were developed in the race context. He apparently sees that, yes, they can apply here. The big outlines of the law in this area seem to be the same, even though he didn't decide the key issues in this case. He cited those cases approvingly, and he said there can be non-discrimination rules like Colorado's that apply to same-sex couples, and some of these past cases will apply. But he said, some of the speech-related arguments presented by the baker could yield a ruling in the baker's favor or in the favor of a small business, not deciding it here. And instead, in his view, there were comments hostile to religion made by people in the agency process. When he decided on that basis, he was applying a different legal rule, a legal rule that the government can't target people because of their religion, can't treat them differently because of their religion. That's not a controversial idea, and that's why that opinion was for 6 members of the court. Justice Thomas wrote his own thing, but Justices Kagan, Breyer, Gorsuch, and Alito all joined Kennedy, and then Thomas joined in the result. It's because that idea is not a controversial one. But if you look behind that, you see enormous night and day difference between how Justices Kagan and Breyer are looking at these issues and how Justices Gorsuch and Alito are looking at these issues. Justice Thomas is looking at them yet a different way.
He focused on the First Amendment free speech issue, which is one that I thought the court would actually pay more attention to because, in this case, the baker, Mr. Phillips, he's not saying I'm discriminating against gays and lesbians. He says, I'll sell you these cupcakes, I'll sell you this cake over here, but you're asking me, an artist, to get in, and that's what he feels he does. He gets involved in making custom cakes. He is contributing his artistic talents to creating a message and saying, government, you can't force me to use my creative talents to endorse a message that I don't believe in. And Thomas was the only justice who actually gave that argument weight in how this issue was decided. Everybody else, you're right, is focused on what we've been talking about, which is and ultimately here giving deference to the baker's religious objections. But Jenny, talk about these other cases, these other bakery cases that were presenting to the Colorado Commission around the same time, because those are important to understand in how the Supreme Court ultimately resolves this, because they point to the Colorado agency's differing treatment in these 2 different types of situations. We need to understand what that other situation is to bring that into the conversation.
Yes, no, that's quite right. And it really is an exercise of, is this thing like this thing, or are these things the same, and which is the same and which is different? So there were 3 other examples of situations where a gentleman went into 3 different bakeries and said, I'd like you to make me a cake with the following design on it. And they were all anti-same-sex couple, anti-LGBT messages that this individual was asking the different bakeries to produce. So there was one that had Bible slogans on it, critical of same-sex relationships, and one with a picture of 2 men holding hands with a big circle and a red line through them, that kind of thing.
Right.
And these were clearly sort of testing actions by an individual named Mr. Jack. It's confusing because it was Jack Phillips, the baker, and this is Mr. Jack who did these 3 tests. But when the bakers in each of these 3 instances said, no, I'm not going to make you a cake. I've made cakes that have a picture of a Bible and it looked beautiful, but I'm not going to do what you've requested, which is the picture of the Bible plus these statements that I consider to be offensive because they're against gay people.
Right.
So Mr. Jack then took the examples of these 3 times when he was refused, because in each time the baker said, no, I won't make that for you, he filed complaints with the state agency. And in each instance, the agency said, well, that's not discrimination against you. These bakers didn't want to do this for you because they considered it offensive.
Considered the message offensive. Yeah.
Included the message offensive. Exactly.
Right.
So there's a couple of things to pull out here, and you see when you read the different concurring opinions and the dissenting opinion by Justice Ginsburg, joined by Justice Sotomayor, that they are doing different comparisons of what's like to like. So, for example, Justice Gorsuch thinks it's a clear showing of differential standards and bias on the part of the commissioners or the state agency, because in these 4 different examples, the cake was refused, and in one, they said it was discrimination against Charlie and David, and in the 3 others, it was not discrimination against Mr. Jack. They say it's bias.
Well, what Kennedy says in looking at these 2 different situations is looking at the record from the Colorado agency, which said when Mr. Jack comes in and asks for a cake shaped like a Bible and asks for anti-gay messages, actual words, or what were interpreted as being anti-gay messages on the cake, and when those 3 bakers refused to create that cake, they were justified in refusing that business. It wasn't discriminatory. It was just refusing to participate in something that was offensive. And on the other hand, where Jack Phillips, the baker in the who refused to make a cake for this gay couple, his views were offensive. And that's how Kennedy seems to me to be splitting it up. He's saying, in one case, the commission is pronouncing the speech offensive or the message is offensive as a basis for denying the cakes. And in the other, he's saying the religious views are offensive and we're not going to give weight to those religious views. We might say he has a right to views, as you said at the outset. He may have a right to those beliefs, but he doesn't have a right to them where they're offensive as a basis for denying service to this couple.
And it clearly made a difference to Justice Kennedy, and we could see this in the comments he made during the oral argument of the case back in December, that certain members of the commission themselves personally expressed during the hearings that were held that when religion is used as an excuse for things like the Holocaust or things like slavery, it's a vehicle, it's rhetoric for things that are very harmful. And Kennedy took that as evidence that the commissioners themselves were biased against religion and were not giving Jack Phillips the sort of neutral, respectful hearing to which he was entitled. And the concurring opinion by Justice Kagan for herself and Justice Breyer, sort of also latch on to that idea. There's a couple things to unpack here, and I think the dissent points this out, that the bakers who refused to make the cakes with anti-gay messages, at least from what we know about those instances, was that they said they wouldn't make that kind of message for anyone. It wasn't about the sexual orientation or any other personal characteristic of Mr. Jack, the would-be customer, or anyone else. They won't make cakes with those messages for anyone. Whereas Jack Phillips, the baker in the Masterpiece, who has the Masterpiece Bakery, He makes wedding cakes in general for everyone. And so it wasn't a difference in the product, that is, a friendly message versus an unfriendly message, bakers that will make friendly messages for everyone, unfriendly messages for no one, but rather the thing that was at issue when Jack Phillips refused Charlie and David was their sexual orientation. It was the same product. It was the same product. Jenny, the difference was the person.
But that's clearly the result, because you would think, and be I think safe in assuming that you're only going to be asked to make a same-sex wedding cake for a same-sex couple. But Jack Phillips, the baker in this case, is saying, and this, at least the way Justice Kennedy and the others are sussing it out, that it is the same situation as the other. It's about the message. It's not about discrimination of the person or of a class of persons. It's really about the message, and that message violates Jack Phillips, the baker's religious beliefs. That's how they're framing the issue.
That's how they're framing the issue, and the dissent disagrees with the appropriate framing. I think that there's a difference in the examples if you have a cake with actual words on it versus just the cake. Now that people disagree about this, that the different opinions are looking at this differently. Jack Phillips says, when I make a cake, I intend to express, and I believe I'm conveying a message of celebration of that marriage, and that I'm participating in the wedding by making the cake. The other way it can be seen is that, and what has been the law in the past generally, is that if you're in the business of generating, sort of printing or written materials or videography or photography, things that clearly can be expressive in nature and artistic in nature, the communication is the communication of the customer, not the communication of the vendor, and that providing goods or services for a wedding isn't actually participating in the wedding. Now, certainly the officiant is participating. There are ushers are participating, but the caterer or the florist or the baker isn't participating. They're providing the same things that they provide to any customer, and that people usually wouldn't believe that the caterer, by providing whatever they provide, is saying, and I think this is a great match, Sally and Fred are made for each other, and I give them my personal blessing. People don't actually think that that's what a vendor is doing if they sell goods or services. So there is something in Justice Kennedy's analysis of accepting the framing. It's of course the subjective beliefs of the baker, that this is how he goes about his business. We can understand that that's sincere and important. But the doctrine had been, and the state court decisions dealing with these cases have said, based on previous U.S. Supreme Court cases, it's not just that a person thinks they're communicating something with their conduct. There has to be a message that's understandable to other people for it to be the kind of expressive conduct that should be protected. If you think you're conveying something, but nobody would have any idea that that's what's going on, then it's not an effective expression. Now, because we see this series of opinions in this case, and they really are coming at some of these important issues from different places, that is, we have a lot of work left for a future day. We have these core issues about how should we understand expressive conduct, what kind of protection should they be, is the standard going to change? And what about religious rights to not follow a generally applicable neutral law? Are we going to have a change in the what has been the Smith test, the law that the that the U.S. Supreme Court gave us in 1990? Is that standard going to change? Certainly seems like Justice Gorsuch thinks that the law should change a bit from his citing cases and discussing cases that predated that. We have a lot that's up in the air, frankly.
Right, and there is a whole line of cases that look at what is the scope of expression, what is expressive conduct, and I don't think this is the case that really gets at that unless you're looking at Justice Thomas's opinion, because he's the only one that really goes into that. But I do think that there seems, although this case really gets decided on the facts of the case, and that's why I was suggesting in the beginning, maybe this is narrow in its implications, but still a signal, perhaps, because of the focus on the religious views of this individual, and I wonder if we would just change the facts a little bit, just to tease out how this might play out in other situations. I mean, what if instead this was a Jewish baker and somebody comes in and says, I want you to make me a cake for my white supremacist meeting this afternoon? You know,
well, and so here's the way I often think about this is look, the business gets to decide what they make and not to whom they will sell. So, for example, the kosher delicatessen gets to decide that it's going to make chicken soup. It's not going to make ham and cheese sandwiches.
right.
But it does not get to say, I'm not selling you my chicken soup because of your race or because of your religion, because you don't keep kosher, or because you don't have your head covered, or because you're a same-sex couple. That presumes there's a law in place that prohibits discrimination, and that's not true in more than half the states. But that's why we say for the doctor, you get to choose if you're going to specialize in infertility and do inseminations. And if you've decided that's what you're going to offer to the public, you should not be able to withhold those services from some people. If you have religious objections to lesbian couples having kids, then, I mean, in this instance, the doctor said, I'd be happy to deliver the baby and do prenatal care. I just won't do the insemination. Well, then don't specialize in infertility. I mean, and the same would be true for Jack Phillips. If he has religious beliefs about weddings, then he should make lots of other wonderful, delicious products. He can choose what to make, but not to whom he's going to sell it. That has been the rule, and the question is whether the Supreme Court will hold to those principles, or whether the next case that goes up gives us some changes in the law. I should say, again, Justice Kennedy leads off by citing some of the important civil rights cases that have framed this area, Piggy Park, for example, and the Smith case, for example. So at least it indicates that he's not intending to make big changes in the law, and he wrote for 6 justices, and Chief Justice Roberts joined that opinion too. So it does indicate that some key landmarks are likely to stay in place, but what we don't know is whether there will be exceptions that involve some mix of religion and speech in narrow contexts. That's what we don't know.
He also alludes to his own marriage equality opinion, and he talks about the dignity that gays and lesbians are entitled to under law, but then goes on to analyze the facts of this case the way he does. I'm wondering, and you've been in the trenches on these issues, as you say, for the last 2 decades. I'm wondering what may be unspoken in all of this, and in all of the words of the various opinions that make up this Supreme Court decision. Without meaning to get into another hour, because we might have to have a second hour on this question, but it's kind of calling out, I think, that there was obviously a time in our country's history when religious views on race were tolerated. And then there comes a point where, and it really took the Supreme Court in the end, whether it's Brown versus Board of Education, or the Loving interracial marriage case, or this Piggy Park case, which is one of my favorites because I do love barbecue. These are cases that come in the 1950s and the 1960s and the 1970s in our country's legal history, our constitutional history. And now it would, I think, still be seen as something not acceptable that in the course of the marketplace, in business, in the dealings of shops and hotels and restaurants and bakeries, that somebody could discriminate on the basis of a religious objection to race.
Mm-hmm.
But is what is unspoken here that we haven't yet reached that point. There's been a lot of progress. Kennedy wrote the Obergefell decision, finding a constitutional right in marriage equality. But is this court allowing deference to religiously held views about gays and lesbians that would not be tolerated in the same way because of where we've come, the distance we've traveled as a country, and as we've traveled constitutionally when it comes to race?
When it comes to race, and I think also when it comes to gender roles and opportunities for women, it's not the race. The race precedents are very important, and it is, I think, telling and important that some of these same arguments and tension points and attempts to draw lines did happen in the past. So the historical echoes are very strong, even though the social conditions about race discrimination and sexual orientation discrimination and the history of those movements, of course, is very different. But we also need to remember that some similar questions came up about roles, opportunities for women, professional opportunities, and legal rights for women, where sincere religious arguments were made that women should be at home taking care of children, that roles should be very strictly defined differently for women and for men. Sincerely held religious beliefs, but not to be enacted into law and not to be imposed on other people in the public marketplace. So I do think we do well to remember that the work to reduce legally official race discrimination was about many cases and many activities over many years. It wasn't just one or two cases, even though we frequently cite a couple of principal cases. There actually were quite a few. It's not so shocking if we think about it that it might take multiple cases for the law to get where we think it needs to be in terms of applying the same rules to everyone, including LGBT Americans, that the rules really need to be consistent for all of us, and that respect for religion needs to be the same for everyone, and it needs to not be an excuse for excluding or discriminating against anyone. It may take a couple of steps to get there. Now, it's clear from a couple of the decisions, Justices Gorsuch, Alito, and Thomas in particular, it appears, are really not receptive to that idea. But
they're very worried about, in a post-marriage equality world, they're very worried about the people whose religious views are offended by that still, even though that's
of course
law.
They are. Of course they are. And I think one of the things that this decision calls on many of us to just talk to each other about a bit is the idea that the suggestion that it is inappropriate for the government to be critical of religion-based discrimination. So, for example, if we put it in the context of race or sex, I think many people would agree that if there is refusal of services to women based on religion, or the idea that women shouldn't be able to be hired or served unless they have a head covering, or that they be restricted to certain jobs, or refused the opportunity to buy a car because the business owner has a sincere religious belief that women shouldn't drive, as has been the rule in Saudi Arabia, for example. A car dealer should not be able to refuse to sell a car to a woman based on sincerely held religious beliefs.
But that sounds, hearing you say that, it sounds so, of course that sounds right, but but why not? Because there are going to be a lot of people that say, well, this is America. You can't tell me that I can't. And this is from Justice Gorsuch's opinion. He says, just as it is the proudest boast of our free speech jurisprudence that we protect speech that we hate. It must be the proudest boast of our free exercise jurisprudence that we protect religious beliefs that we find offensive. So why
right, but he's
isn't
not,
that true here?
But that's the difference between protecting the freedom to believe something and saying, but you can't run your business based on that belief. You can't refuse customers based on that belief. You can hold that belief. Absolutely, you can. But you can't refuse customers on that belief. And if your religion requires you to refuse customers on that belief, you need to think about another way to make your living. That's what the California Supreme Court said about the landlord. And some people say, well, but that's unfair, because what if the person has been operating a car dealership for lots of years? That's what he knows how to do. Well, okay, but he's going to have to think of another way to make his living, because no, he's not allowed to refuse to sell cars to women or to refuse to sell cakes to same-sex couples.
Or to serve blacks at the barbecue. I mean,
or to serve blacks at the barbecue. It made some people really unhappy to be told that they had to serve African-American patrons. Very, very unhappy. And our history of getting through that period, and look, the reality is we're not through that period now. If we look at what's going on, and that's why we all have a stake in the basic principle that everybody has a place and everybody deserves equal treatment by businesses or equal treatment in the public sphere. This is not going into anyone's church, synagogue, or mosque, or telling them what to teach in their religious school. But if you're operating a business where you offer goods or services to everyone, you need to serve everyone equally. And if you can't do that, then pick what you can do in a way that treats everybody equally. If we don't do that, then, wow, we're going back generations to situations that are incredibly painful and tear the country apart. I think that is what some folks lose sight of. In the LGBT movement, we don't need to call anybody names. We don't have to be hostile and angry toward people who don't yet see us for the full human beings that we are. But we do need to say views that call for people to be treated unequally and ostracized and not given the same treatment. We need to be able to critique those views, and elected officials who are charged to enforce the equality laws need to be able to enforce those equality laws. Otherwise, we're all going to lose out, because, we're a very diverse society, and one day it's the same-sex couples, the next day it's Muslims, the next day it's Jews. We just can't go down that path.
Jenny, this is not going to be the last case that tackles these issues and tries to grapple with this tension, I'm sure, right? This is, as you say, going to have to play out in other disputes that come up to the court and other cases that force the court to grapple much more directly with these core issues that we've been talking about. That's right.
That's the one thing we know. We know a couple things for sure from the Masterpiece Cakeshop decision, and among them is that these issues are going to be back in front of the court. Could even be soon. There's a cert petition in the Arlene Flowers florist case out of Washington that is set to be considered tomorrow when the judges meet for conference. And there are other cases in the pipeline. So we know that there will be more cases and there will be more conversation. And so, yes, we'll have to get together again and keep on talking about it.
Jennifer Pizer, Law and Policy Director for Lambda Legal, thank you so much for being on the program. It was a pleasure and a very, very important conversation. Thank you so much.